Welcome. Good afternoon, everyone. Welcome to this session. As you heard, my name is Bryan Zutel. I'm a real estate attorney. Been in real estate law for about 15 years. I've been in the real estate industry for over 20 years. I married into a real estate family. My wife's mom was a mortgage broker. Her dad was a 1031 exchange accommodator. My dad's an attorney, so I decided to marry the two together, and now I'm a real estate attorney. I eat, drink, sleep real estate. I focus almost primarily on real estate in my practice and have done so for many years. I'm also in the trenches sometimes with you guys, as I have a real estate brokerage. We do kind of certain specialized transactions, very difficult transactions, things involving death, zombie mortgages, if you know what those are, other special things. So I have worked in and for real estate brokerages. I've worked in the trenches where you guys are and continue to do so. So I use the RPA just like you guys do. I use the forms just like you guys do. So we're here today talking about, well, before we do that, I have to give you my attorney disclaimer. This will be hopefully the only time I sound like an attorney, according to Jeremy. I'm an attorney. I'm not your attorney. So everything I say here today is informational for you. So please, please, if you have further questions, if you're going to make an important life decision, consult an attorney. Now, with that said, today we're here for our 2024 new year, new forms, new laws, new cases. I'm only going to touch on a few in each of those, and there's plenty more to be said in each of those topics, but we only have so much time. So, new and revised forms, new and revised CAR forms. Lucky for everyone, at least right now, there's really only one new form to discuss. There's some revised forms that we'll talk about. You're familiar with those. We'll talk about how they've been revised, but there's not too much new right now for the December 2023 CAR forms releases. So we're going to be talking about the Buyer Homeowners Insurance Advisory. That's the new one, and we'll go through that in a little bit. And then we're going to talk about revisions to the residential lease agreement, the application to lease or rent, the ADU disclosure, which has now been added on the SPQ, and as well as another perhaps separate ADU disclosure that's coming soon, the residential listing agreement, which was modified in a way, and I know we just went through the RPA extensive revision. It's probably going to have to be revised again. Not as extensively, but you'll find out why, and you've probably read in the news about all the lawsuits and everything changing in real estate. There's going to be something. There's going to be an RPA change here coming soon. All right, so let's talk about the Buyer Homeowners Insurance Advisory. Now, as I'm sure all of you are aware, insurance is difficult in this state. And it's getting more and more difficult to obtain affordable, reasonable insurance on your properties, on the properties that your clients are buying. As I'm sure you've run into before, you have clients that are saying, oh boy, I didn't realize it was going to cost me $10,000 a year for that insurance that I have to have, right? Because I want to protect my home, because my mortgage company requires it, because I don't want to leave things to fate. So what do you do? Now, we don't have this as much anymore. We're not doing as many non-contingent offers, hopefully. I don't know, maybe some of you folks are from the Bay Area. They are still doing them in the Bay Area. I tell you, I just got a call a week or two ago from a buyer who was saying, hey, my agent convinced me to submit a non-contingent offer. I submitted it, and something went wrong. And what are you going to do about it? Well, in this situation, they weren't very well advised, and there might be some agent liability there. Here, we probably still have the contingencies in place. And remember, there is a contingency for insurance. There's a contingency built in the RPA for the ability of the buyer to investigate and secure insurance on the property, or to cancel if they don't like the insurance options that they're being provided. If you're going in with a non-contingent offer, your client is going in naked. Your client has no option to cancel if insurance is $20,000 or $2,000. So make sure your contingencies are in place and you're not releasing those contingencies, particularly the investigation contingencies, until your client has secured that insurance. We all know California's property insurance market is difficult. So what did CAR do about it? Well, the thing that they did, at least as of right now, or one of the things that they did, is release the buyer homeowner's insurance advisory. This is an advisory from the broker to the buyer advising, explore all options. Revolutionary, right? Explore all options. No, it advises the buyers that insurance is difficult to obtain in the state. They really might have to go explore to check out their options, maybe to talk to an insurance broker. They need to make sure that they are satisfied before they remove their contingencies that this insurance will work for them at the right price. If not, then you need to be advising your clients of their options to cancel or find other insurance. Use this form. Use this form. I don't remember if they were going to bundle it. I think they were talking about bundling it with the RPA. I don't know if they've done that yet. You might have to search it within the library, but use this form, the BIHA, and advise your clients, walk them through this form. It's a pretty simple form. It's one page. It basically says, I, broker, am advising you, buyer, to research all of your insurance options and do not move forward until you are satisfied. All right, our next form, and we'll get into this a little bit more with the new laws as well, but as you might know, landlord-tenant law is extremely difficult in this state and is becoming more and more so every week, every month. So CAR has tried to keep up with that in some ways, and one of the revisions that they had to make, I don't know if anyone does leasing in here, property management in here, but one of the revisions they had to make was to clarify periodic pest control only applies to houses. So if you're living in an apartment, if you're living in a condo, the periodic pest control that's referenced there does not apply to you. Again, subject to negotiations. There's all kinds of ways that you can make this apply to your condos or apartments if you want. Also, some of you might know the word landlord is no longer in vogue. So now the word is housing provider, okay? Housing provider. If you see the word landlord, you know, it's still out there, but housing provider is now the new word. There was some confusion over the additional insured language in the lease agreement, in the form lease agreement. If you don't deal with insurance much or claims, it's probably no big deal to you, but there's a clarification here that in the insurance world, which means something pretty important to insurers, housing provider and property manager are additional interested parties, not additional insureds. So housing provider and property manager are additional interested parties, not additional insureds. And there's a distinction in the insurance world as to what that means. Make sure you read that, advise, and at the end of the day, you know, it might have the same outcome depending on the claim. Now, as I said, and as you'll see in the new laws are changing all the time. You could have a city, a county, the state pass housing laws that will affect your business, your property management, your leasing. So CAR just added a local jurisdiction catch-all saying, make sure you check with your city, your county, your state for what are the rules when you make this lease, okay? Because they can't even keep up with them. Gov. Hutchinson, who I heard speak a few times, I mean, they are trying to just devote themselves to the laws of California and once in a while to the laws of, say, the biggest counties, LA County, San Francisco County. There's no way to keep up on a city by city level here. So there's this catch-all in there. Make sure that you are using the newest of the forms when you are doing leases. Also, along the same lines, there has been multiple changes in terms of how one can apply to lease or rent a property. So there's a revision in the LRA form as to the screening fee section. There's a full versus a partial screening that is paid by the tenant that's been updated in there as an option. There's other requirements for leases. True or false? In California, you can reject a Section 8 tenant. Exactly, false. It is now illegal to reject on the basis of Section 8 income only a tenant. So you have to make sure that you are evaluating the tenant as a whole person. There are some other requirements for leases. There's other requirements for evaluating. We'll get into those with the new laws as well regarding Section 8 tenants and how you look at them. Make sure you're using the most up-to-date LRA form if you're doing any leases. ADU is pretty popular, right? Getting more and more popular. We'll talk about some new laws with this in a sec, but there was an ADU disclosure that was added to the SPQ. Make sure you're using the SPQ, obviously, for any transactions that it's applicable to. But Section 8D, it was inserted into the SPQ to inform the potential buyer whether there's an ADU, whether it was built with a permit, whether there are separate utilities and meters to this ADU, all the important things that you want to know when purchasing a property with an ADU. Also be aware that as far as I understand, in development right now with the Forms Committee of CAR and potentially coming soon is a separate ADU disclosure or advisory, depending on how they craft it, that will be helpful as well to be used and given to any buyers and sellers on a property with an ADU. The residential listing agreement. So how many months can a listing last? 24. Who said 24? You must have visited the new laws seminars recently. Yes, 24. There was a somewhat humorous, somewhat sad story that apparently there was a company who was offering folks $1,000, $2,000, something to that effect, to sign a listing agreement for a period of 50 years. 50 years, 40 years, whatever they could get. And then they would record this on the title to the property. So there's no getting around the knowledge of this listing agreement. Well, the governor got involved, the attorney general got involved, they're investigating them, and the California legislature got involved. They passed a law that we'll look at in a minute saying, no. 24 months. 24 months is your maximum on a listing agreement, and you're not recording it against the property. We'll see what happens with those out there. I haven't run into any of those. I don't know if any of you folks have, but it might be struck down by a court. It seems unconscionable, basically, what that company was doing. My opinion, maximum 24 months and no recording. So that's it for the forms. As I told you, pretty painless, right? So far. We're going to get into the new laws now. All right. How many bills signed by Governor Newsom last year? Too many. No, I'm looking for a number. Throw it out. 1185. Oh, wow. Okay, you get closest, but you went over, so you don't win. The Price is Right. It's about 1,000, just a little shy of 1,000. How many of them deal with real estate? Lose a zero, 100, okay? We're going to talk about 10 today. So 1,000, 110, less than 10 that we're going to talk about today. If you don't see anything on here that you're interested in, if you want to read through all the laws, CAR puts out a great guide in their 2024 new laws section. You go on the website, you search that, you could read through it. Boy, oh boy, is there a lot there. All right, we all know the hazards booklet, right? You remember when it was printed, you had to actually hand it, and then it went online, you put it into a PDF. Anyone ever read through it? A little bit, somewhat, hopefully. Yeah, read cover to cover. I don't know if anyone's ever read cover to cover. Maybe one of us has. But you got to give it to them, right? On an applicable transaction, you do need to give them the hazard booklet. Thankfully, now it's in PDF, so it's pretty easy to throw it into your email and tell the buyer to check this out. There's an update there's 6 sections right now in the booklet. There's going to be an update coming up with 3 more sections for the booklet. So there's going to be chapters on wildfires, climate change, and sea level rise. So your booklet's going to increase. It's going to get a little bigger, but never fear. I didn't even realize this till I was researching this law. The law didn't give any time deadline to make these updates, and the law didn't give any funding to people to make these updates. So the legislature said, make these updates, do it whenever, and we're not sure who's going to pay for it. So no time estimate for these updates, so stay tuned. I don't know. We'll see when they get put out, I'm sure that CAR will give us plenty of warning for it. Okay, I was talking to somebody recently, just today, about the new flipper disclosure. Flipper kind of turning into a bad word, so, maybe you don't use the word flipper. The legislature thought it was okay, so they used the word flipper. Effective July 1, 2024, there's going to be a new statute in the Civil Code. Civil Code 1102, if you might know, that's your TDS section, and that describes a lot of the disclosures that you make. Civil Code 1102.6H is going to be inserted, and this is going to affect flippers of residential 1 to 4 units who must disclose recent repairs and renovations. So again, effective only July 1, 2024. Property that is sold July 1, 2024. If resold within 18 months of purchase. Why 18 months equals a flipper, not 2 years, not 1 year, I don't know. But the legislature says 18 months or less turns you into a flipper. What do you have to do if you're a flipper? You have to disclose, I take it back. This is also only applicable if renovations are performed by a contractor. There are other requirements if you are Joe Contractor who's actually doing this work yourself. But if it's performed by a separate contractor, you will have to disclose room additions, structural modifications, other alterations, repairs, and provide copies of permits and contractor information. Now, personal opinion time, attorney time. I would always recommend that any of my clients selling a property that has had this level of renovation with permits or anything, disclose it. I don't really see this as being that onerous as maybe some other folks do. I think that this kind of work requiring permits done by a contractor, room additions, structural modifications, you really should be already disclosing this, and you should be providing the contractor info, and you should be providing a copy of the permits. Soon, it might be mandatory if you're a flipper. NHD statement. A lot of confusion over fire zones, over whether you're in the right fire hazard zone. 3 categories of fire hazard severity zones: high, very high in a state area, and very high in a local area. Depending on which category you're in, you have certain disclosure requirements. If you're in these areas and the yes box is checked, you have certain defensible space disclosures. Thankfully, the big NHD companies have gotten involved in this now and have made the form a bit easier to read, to use, to follow, and to pass on. Again, you're not supposed to be the expert in these things. You are a real estate agent, broker, or involved in the real estate industry. But the NHD company and passing along their report is probably going to be the easiest thing for you, encouraging your buyers to read through that report and to understand a very complicated law that is hopefully going to be made a little clearer as to whether your property is in there or not with the new NHD report format. Get your NHD statement from a good company. Workplace violence. Workplace violence. Anybody have workplace violence here? Don't raise your hands. The legislature has determined that workplace violence prevention plans are going to be mandatory for many businesses. The CAR and others are still seeking an exclusion for real estate businesses, for small brokerages, but we'll see whether they're able to get it. Law is effective July 1, 2024. Gov and other attorneys at CAR are reassuring everyone, don't worry, this will not sneak up on you. We will make sure you have plenty of warning about this. Basically, employers must establish, implement, and maintain an effective workplace violence prevention program, a WVPP. Possible exemption for small real estate brokerages. We'll see. It's possible right now. Stay tuned to your CAR emails. And if they're not able to get the exemption, they will put out a model WVPP, which you can basically use and make your compliance document for this law. ADUs again. ADUs sold separately. there is a law now about the possibility of selling an ADU as if it was a condo on your property. Now, it's only a possibility. It's only been enabled by the legislature right now. They said, we're going to leave it to the local cities and jurisdictions to adopt an ordinance if they want to allow the sale of an ADU, basically a condo. I haven't heard of any cities doing this yet. I would be surprised. This is going to create all kinds of confusion with the assessor, with putting new APNs on it, with having a condominium plan, with maybe having CC&Rs. You sell to your tenant, he's your neighbor for life, right? You can't get rid of him after that. So we'll see. So there's an ADU. It's discretionary. It's left to the cities. We'll see what cities really do with it. But again, with the goal of trying to promote and to encourage housing in our state. Interesting idea, maybe right motive, maybe not the best plan. We'll see. Ability to pay. So here we're getting back into the landlord-tenant. So Section 8 tenants. Section 8 tenants. The landlord must evaluate the quote offer to pay or ability to pay in lieu of reliance on credit history and reports to assess tenant application. So with a Section 8 tenant, there is the possibility you won't be able to have a credit report for them, and you won't be able to evaluate their credit history. Doesn't apply outside of Section 8. Section 8 gets a pass on this one. There's still the possibility to evaluate alternative evidence of reasonable ability to pay. So, the Section 8 tenant probably can't rent a $20,000 home in Laguna Beach with this. So you will be able to evaluate their reasonable ability to pay, but you can't evaluate the credit history. Also, the landlord can request documents to verify employment, to verify the identity of the person applying, can request landlord references, and can verify the identity of the applicant. Security deposits. What is the maximum security deposit for a? Not yet right now. We're still in February. Yes, two months unfurnished, 3 months furnished. Exactly. Coming July 1, 2024, and this law does not seem retroactive. I put that in there, but this law, July 1, 2024, landlords may only collect 1 month's rent, furnished or unfurnished. Yes, 1 month's rent, furnished or unfurnished, in addition to the first month's rent, which you usually collect. There's an exception for small landlords. It was not made very plain in there. No more than 2 residential rental properties, no more than a total of 4 units. And this does seem to apply wherever you own the property. So if you own properties in Arizona, that counts toward this. If you own properties in Germany, it counts towards this. No more than 2 residential rental properties, no more than 4 units for that exception. If you have a service member, you're capped at 1 no matter how many or how few properties you own. 1 month security deposit for a service member. What, the pet question? Okay, so we got a pet question. Oh boy, I'm gonna go down that rabbit trail. No, you cannot charge the pet deposit, or I would not advise to be charging the pet deposit. The pet deposit is getting a lot of people in trouble right now. I think we're just going to have to be set with the 1 month and keep a close eye on that tenant. Okay, can you say no pets? You can say no pets, but remember, there are service animals, there are emotional support animals. You cannot say no to those. They're separate tracks you need to go down. The rabbit might be an emotional support animal. Yes, you can say no pets. In most jurisdictions, there's that county up the road there, LA County is getting very tough on this. But for now, yes, you can say no pets. Term of tenancy, this is effective April 1, 2024. there was a law that was passed in late 2019. It was set to go into place early 2020. And then the whole COVID thing hit, and people seem to forget or not be aware of it or what. But the TPA, the Tenant Protection Act, went into effect January 1, 2020, if I remember correctly. And that is a statewide rent control law. I still get, maybe once every week, I talk to a landlord client who doesn't realize that there is a statewide rent control law. So the TPA is very important to know, Civil Code 1946.2. And this applies to most properties except, at least right now, except single family residences, duplexes where one unit is owner occupied, and a number of other very obscure kind of properties. So under the TPA, you must have good cause to terminate the tenancy. What is good cause? It's laid out for you there in the statute. There's both at fault and fault. There's both at fault and no fault good cause reasons. At fault, most common might be failure to pay rent. No fault, most common of those have been, I want to move my mom in, the relative move in, or the substantial remodel, substantial renovation. So the no fault just cause reasons are being changed April 1, 2024. So there are significant restrictions being put into place for, and let me clarify this too. I'm talking California law here. I'm talking only California law. LA County has a separate statute that kind of overlays or applies on this. LA City has a separate statute. Santa Ana has a statute. Buena Park was talking about a statute. Costa Mesa passed a statute. I think that's it for Orange County. LA, you know, they have a lot more cities up there. Each of those cities you'll have to look into. I'm talking only California right now under the TPA with the application for terminating a tenancy. There's significant restrictions being put on the owner move-in, no fault eviction. So that's where you want to move in your dad, your mom, your children, your grandparents, your grandchildren. To be fair, there was abuse of this, maybe, particularly during COVID, but even now, there was abuse of the owner move-in. You know, I'm moving my mom in and then mom never moves in. Okay, so it was a way to terminate tenancies. The legislature saw this and they are restricting this very much. So there's requirements for the identification of the person that's going to be moving in that you have to provide to the tenant. There are requirements for how quickly that person must move in, for how long the person must live there, and for the type of people that will qualify for the owner move-in. So that's the owner move-in. And then the other one that was commonly used was, hey, I need to do a substantial remodel on the home. Tenant moves out, and you change a mirror. Okay. That was an abuse of the statute. And so the legislature saw that, and they are significantly restricting the substantial remodel, no fault eviction. So now it's going to require things like getting permits, starting the work within 30 days, and a number of other items that are required to qualify for a substantial remodel eviction. A termination notice that doesn't comply with the TPA is now void. There were times that we could fight about this in court, say something like substantial compliance. I got really close, Judge. I mean, look, I missed this or that. The legislature is really trying to crack down on this. So anything that does not comply with the strict letter of the law of the TPA is probably going to be void and unenforceable in court. So you have to be very careful with this. And it's almost at the point, right, where CAR, you know, they used to provide you the form so you could go on there, you could choose the right form, you could fill it out. They are really, really close to just saying, we're done with these forms. We're going to leave this to property managers. We're going to leave this to attorneys. Because a violation of the TPA also carries with it damages, actual damages, attorney fees, cost, and potential treble damages. That means potential triple damages. There was a case up in San Francisco. Again, they have a much more extensive, far-reaching statute up there, but there was a case in San Francisco where a landlord did it the wrong way. A landlord got challenged in court. A jury came back and awarded, if I remember right, $130,000 to the tenant. and there's the potential for triple damages there. So we're looking at this, we're saying, boy, this is more and more complicated every day, and we're just talking the state level. We're not talking the county level or the city level. For instance, the county level, I have a case going on right now, County of LA. It's an unincorporated LA County area, and under the County of LA statute, you cannot do an eviction of a property if you're going to do a substantial remodel of it. Instead, you have to put your tenant up at a hotel while you do the renovation and then invite the tenant back in. And the rent's a whole different issue under the statute. So remember, every county is different, and you have to be aware of where you are. That's why, please, 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 don't be a realtor who occasionally does property management. It has just gotten to the point where it is confusing for attorneys who are in this field day in and day out. It is confusing for property managers who, might say, well, we always did it this way. No, 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 no. This is a very complicated area of the law. So please, if you're going to do property management, if you're going to do leasing, make sure you are up to date on all of the laws in the state, county, and city that you practice in. Oh, we got the Irvine Company question. The Irvine Company. Trying to think what stories I can tell about the Irvine Company. Irvine Company has a bad reputation, let's say. Irvine Company, there's even public cases and Court of Appeal cases that I know of it with the Irvine Company. No, this law is not, Irvine Company is not exempt from any of this. But sometimes the more forceful one can win out over the tenant. Sometimes the tenant doesn't know their rights for these laws. And again, if we're talking Irvine Company, so if we're talking Irvine, different than, Irvine Company owns properties in LA. If they own in LA, again, there's going to be even stricter, more tenant-friendly laws there. Irvine Company doesn't matter from mom and pop landlord. These laws are going to apply to them. New cases. All right, the big one, I'm sure everyone read about. Boy, it was all over CNN, everywhere. Kansas City, Missouri jury verdict, the Sitzer case. The Sitzer case involved sellers. It was a class action that was certified sellers of more than 260,000 homes in Missouri, Kansas, and Illinois between 2015 and 2022 who objected to commissions. They claim they were obligated to pay the buyer's brokers. Okay? So they took it to a jury verdict, and the jury returned a $1.78 billion verdict against NAR, Berkshire, Keller Williams, and others. And there's still potentially more to come. There is the opportunity for the judge in this case to triple the damages that were awarded against them based upon antitrust laws. So there is a treble damages provision in the antitrust law, and that decision still remains to be seen from that judge. The home sellers complained this model suppressed competition by keeping commissions for buyer brokers in the 2.5% to 3% range, despite the brokers' diminishing role, with many buyers able to find homes independently online. Now, as part of this antitrust claim, there's also the potential for the judge to impose an injunction, because an injunction was also requested. An injunction is a court order prohibiting something or ordering something to be done. So this judge has the potential of issuing a nationwide injunction on the practice of paying buyer brokers. Not likely, in my opinion. It's a possibility. I throw it out there. I don't think it's likely. There's also the possibility of a statewide, a Missouri-wide injunction. A potential, I can see it. I wouldn't put a high percentage on it, but it is a possibility. Or a specific injunction. I think that this one's actually pretty likely. A specific injunction that prohibits certain policies and rules of NAR, including with regard to the payment of buyer compensation. Remains to be seen. I don't know when that judge is going to make his decision. there's appeals and years ahead with this, so nobody freak out, nobody do anything. I'll talk in a short while about at least one thing that I'm suggesting that people do. But again, I'm going to give my opinion on this. I don't know if any of you have heard CAR, NAR folks talk about this, try to say, oh, no big deal, we're going to beat it, it's going to go away. I got to tell you, I think when a jury verdict is returned like this, I think there's the potential for significant change to happen here. The real estate industry is going to change in some way. It's not going to be business as usual. How that looks, none of us know. I'll give you at least, in a sec, I'll give you at least one idea that I kind of have as to what's going to happen in the future. I talked to folks, I think last year at this gathering, about NAR versus United States, a 2022 case. NAR was in discussions and negotiations with the Department of Justice. As you know, there was a change of administration in 2021. New administration came in, tried to change some of the agreed upon deal points with NAR. And NAR said, no, we had a deal. Department of Justice said, I don't care, new administration. They fought about it. The district judge said, nope, a deal's a deal, and you're sticking to the deal, DOJ. So the district court enforced that, and then after that order went into place, the DOJ, Department of Justice, appealed. So they appealed to the DC Circuit Court of Appeals, and this regarded the disclosure of compensation for the buyer agent, listings excluding compensation, no offer of free buyer brokerage services. These are some of the things they agreed upon. So that appeal, again, went up to the DC Circuit, oral argument December 1, 2023. So we're, about 75 days out from there now. So I would think we'll probably have a decision on this within the next month or two from the DC Circuit. And we'll see what they do. Again, I think the rule that a deal's a deal is a pretty strong one, and I have a good feeling that the circuit court will enforce the deal that was made between NAR and the prior administration's Department of Justice, and so we'll have a few changes going into place regarding compensation being disclosed and never again saying your buyer broker services are free. There's ongoing federal and state litigation all the time. Make sure you keep up to date on that. There are copycat lawsuits of the Missouri case, including one that was just filed in NorCal a month or two ago, I think. I didn't see any for Southern California yet. I mean, guys, it's coming. I got to tell you, in my opinion, it's coming at some time. They're just waiting to find the right plaintiff to file the class action down here to challenge California. And again, I don't know if you've heard other folks talk about this in CAR. I'm not as hopeful as they are, frankly. I think that it's not going to be business as usual once these cases are filed. There's going to have to be there's going to have to be some changes made regarding cooperation, the commission structuring, the way the MLS works, who pays whom, how transparent that is, how much the buyer and seller know where the money's going, what they're paying for. So here's my big tip to you. I really think that brokers and agents need to start getting familiar with and using the buyer-broker agreement. The buyer-broker agreement, there is a decent possibility that it becomes mandatory within the next few years to use a buyer-broker agreement. It's always been kind of an anomaly, right? Where you just, you take the person around, you submit an offer on their behalf, you get the commission instructions from escrow, you sign those, and then you're good. Most professional relationships, right, have an agreement of some kind. There is a written agreement when you hire an attorney, when you hire a CPA, so why not when you hire a buyer broker? I think that we need to start getting familiar with the buyer broker agreement and using it, justifying your worth, justifying what you're going to do for that buyer, not keeping them in the dark, not pushing off the discussion about compensation just because it's going to come through the seller broker. So start getting familiar with that buyer broker agreement and justify your worth to your clients. There's my contact info, phone number and email, and feel free to give us a call. Go on the website. We do offer a 15-minute complimentary consultation for anyone on there. as well, and always happy to talk to folks from here.